With that, we would move on to the inaugural session for the event. A very pleasant evening to everyone present here. On behalf of the staff and students, I would like to welcome everyone to this conference. A few months ago, the international conference hosted by CMRU School of Legal Studies on Aviation Law was a huge success, with national as well as international experts from around the globe being a part of it. This is the 4th international conference hosted by CMRU School of Legal Studies, this time on international trade law. And we hope this would also turn out to be equally successful as well as resourceful for the scholars and the audience likewise. On this ennoble occasion, I would like to call upon Pranav from BBA LLB second semester to give a traditional start to the event by invoking the blessings of Lord Almighty with an invocation song.
शंकर सुवन भवानी नंदन शंकर सुवन भवानी नंदन आइए गणपति जगवंदन सिद्धि सदन गजावदन विनायक सिद्धि सदन गजावदन विनायक कृपा सिंधु सुंदर सबलायक शंकर सुवन भवानी नंदन आइए गणपति जगवंदन मांगत तुलसी दास मांगत तुलसी दास कर जोरे बस राम सिया मानस मोरे शंकर सुवन भवानी नंदन आइए गणपति जगवंदन आइए गणपति जगवंदन आइए गणपति जगवंदन
Thank you, Pranav, for that wonderful rendition. I would like to now request our beloved Vice Principal, Professor V.J. Praneshwaran, to deliver the welcome address.
A very good evening to all here in India, and also a very good morning and good afternoon to all across the world. A warm welcome to all present. We at CMRU University School of Legal Studies are proud to organize and present the International Conference on Emerging Trends in International Trade. Globalization has seen the expansion of international trade to phenomenal levels. Further, due to rapid industrialization and large-scale production, it has led to expansion of markets. Today, international trade includes services too. Under this background, the World Trade Organization was created to deal with issues and to further integrate the global markets. Its functioning has expanded to great extent, and all aspects of international trade are so covered. The dispute settlement system of the WTO, though one of the most successful international adjudicatory body, is also not free from problems. The conference is organized to set a platform to express, consolidate, and document the views and opinions of all concerned. because what is important is fair and balanced trade and not just free trade. It is my privilege to be formally welcoming the distinguished experts for today's inaugural session. We are joined by Professor Raj Bhala, Brenneisen Distinguished Professor, the University of Kansas, School of Law, and Senior Advisor, Dentons, US LLP. A very warm welcome to you, Professor. We also have Professor Peter van den Bossche, Director of Studies, World Trade Institute, University of Bern. A very warm welcome to you too, Professor. I also welcome our beloved Dean, Professor T.R. Subramania, former Vice Chancellor, Karnataka State Law University, and currently Dean, School of Legal Studies, CMRU University, who will preside over this inaugural function. I welcome all the paper presenters and the registered participants of this international conference. I warmly welcome Dr. Praveen R., Registrar, CMR University, and Dr. Suja Bennett, Dean Academics, and all the distinguished authorities of CMR University for their august presence. A very warm welcome to all the distinguished invitees present for this inauguration. A warm welcome to the faculty and students of CMR University School of Legal Studies and everyone present. Once again, a warm welcome to everyone. Thank you.
Thank you, sir, for your kind remarks. With that, I would like to call upon Professor Mithike Srivastava to take over the session.
Hello, everyone. And thank you, Rishmi. You were doing a great job. I'm not taking over the session. I'm just here to give a brief introduction of our guest of honors here. So we have two guest of honors for the evening. And one of them is Dr. Professor Raj Bhala and Professor Dr. van den Bossche. Our first speaker is Professor Dr. Raj Bhala, but I would also like to add on one point before I start with his introduction, that the Q&A session will happen after both the speakers have addressed the participants here. So please hold on to your questions and don't unmute yourselves while the speakers are talking. Okay, so Professor Bhala is currently the Leo S. Brenneisen Distinguished Professor at the University of Kansas School of Law. Prior to this, he's also held a notable position of the Rice Distinguished Professorship. He also writes a column for Bloomberg Quint Mumbai and is the senior advisor on international law matters for Dentons in the US, which is one of the world's largest law firms. He's written multiple books, but out of which one of them is used globally by over 100 schools for international trade law. In the past, Professor Bhala has also served as the Associate Dean for International and Comparative Law at the Kansas University and has practiced as at the Federal Bank of New York. Also, is one of the 50 Kansans you must know. He's been recognized by the Ingram's Business Magazine in 2020. I am delighted to have you here, sir, and I request you to please address the participants.
Thank you very much, and good morning, good afternoon, and good evening, particularly to all of you in Bangalore and across India. Let me thank you very, very much for this wonderful honor. I'm truly humbled to get to speak with you for a few minutes and enjoy the other speakers and learn from them in the question and answer session. So let me especially thank the Vice Principal and Professor Dr. T.R. Subramania, Professor Srivastava, and Dr. Sandeep Bhatt. And Shivani Rajesh has done a marvelous job in organizing the conference. So thank you to each of you. In the brief time that I have, let me offer the topic of challenges, international trade law challenges in particular, facing the Indo-Pacific region. And I'd like to identify 5 challenges. They all are woven together, they're interrelated by the following proposition. And that is that international trade is obviously not just about trade, about tariffs and non-tariff barriers and trade remedies and intellectual property protection, but it's also about national security. It's about public health policy, and it's even about diversity and equity and inclusion. The trade policies and laws of India and all of the countries in the Indo-Pacific region are inextricably linked to their views, their values on national security, public health, and what we now call DEI, diversity, equity, and inclusion. And let me break down that larger proposition into 5 particular challenges. The first challenge is China. A nation expresses its values partly by who it trades with and what it trades and the terms on which it trades. And it's now been certified by 3 governments, that is the United States, Canada, and the Netherlands, that what is happening in Xinjiang province to the Uyghurs is genocide. And it's meant that the practices of the Chinese Communist Party meet the international legal definition of genocide. We also are all aware of what's happened in Hong Kong in recent years. The national security law, which applies extraterritorially, which means it applies to each one of us participating in this conference today. It applies to each one of us. Again, I'm saying that extraterritorially. It's extraordinary. We've not seen this since the founding of modern China in 1949. And the crimes which are punishable by life in prison include sedition, subversion, terrorism, and undermining the state. Well, we've also seen with the electoral changes in the Legislative Council, LegCo, a body that has successfully functioned with 70 participants, 70 legislatures, and it's now expanded to 90. And instead of having 35 directly elected by the people of Hong Kong, it's down to 20. So we've seen a dilution of democracy. Now, obviously, Hong Kong and the mainland have been robust trading partners for most Indo-Pacific countries and an increasingly important trade partner for India. But will that continue? To what extent will India continue to broaden and deepen its trade relations, given that the facts that I've just outlined portray a very different structure of governance and very different pattern of events than India's founding fathers, and indeed its current government, would endorse. So it's the challenge of the trade and national security and DEI in the sense of human rights and inclusion of the Uyghurs and of the Hong Kong people. That's the challenge. Do we want to broaden and deepen our trade links? The second challenge is India itself. India has long been, as we know, an economy in which the state has dominated the commanding heights, as Prime Minister Nehru, Panditji, put it. But with the 1991 reforms of then Finance Minister and later Prime Minister Manmohan Singh began to open up. Prime Minister Narendra Modi is again trying to reignite many of those reforms. For example, was his ambitious privatization policy. But when it comes to trade, India has never truly endorsed regional trade agreements, free trade agreements. Yes, it has a number of small and commercially insignificant FTAs, but it is withdrawn from the regional comprehensive economic partnership, the one that involves China. Withdrew from that, from RCEP. And it is not, despite calls from many quarters, decided yet to participate in the Comprehensive and Progressive Agreement for a Trans-Pacific Partnership, the CPTPP. So the challenge here is, how does India see its trade policy moving forward with respect to its domestic reforms? And is it going to see that trade will be a vehicle to ignite or reignite those reforms, a stimulus for competition? Or is it going to fall back on what it often has, that its infant industries and its small and medium-sized enterprises need to be protected from free trade agreements, particularly large mega deals like CPTPP? Now notice those free trade agreements are now accepted as instruments of national security. So here again, the link: to what extent might India see its national security policy interwoven with joining FTAs? The third challenge, I'll put it in the context of the US, which is obviously an Indo-Pacific power, but it pertains to China and to India. And that is the challenge of diversity, equity, and inclusion. You have heard from the Chinese side that the US has several serious internal social problems. I speak obviously with you as an Indian American. In fact, the only Indian American who's ever been hired at the University of Kansas School of Law faculty, the only Asian American ever at our law school. And we all know what happened in Atlanta a few weeks ago, and we know about the rising tide of incidents against Asian Americans across the US. More broadly, we worry about continued systematic discrimination against women and against the LGBTQ plus community. Now, you may say, what does that have to do with trade? And I would have said the same thing a few years ago. But let me point out that in Chapter 23 of the Trans-Pacific Partnership, we have an express provision against employment discrimination of women. And in Chapter 23 of the United States-Mexico-Canada Agreement, USMCA, for the first time ever, we have an express provision against employment discrimination, not only against women, but also against the LGBTQ plus community. China obviously faces problems with integration of its minority, non-Han minority peoples, Tibetans and Uyghurs. So too does India. No country has reached modern, developed, advanced societies, to modern economy easily, fully, inclusively, by continuing to, in a stable sense, by continuing to systematically discriminate against part of its population. And now we see provisions in trade agreements talk about what I may say are these human rights. So the challenge, I think, here, this third challenge, is inclusiveness in our trade laws and policies. Fourth, the challenge for the Indo-Pacific region, and indeed the entire world, is, of course, climate change. There's a great deal of discussion about carbon border tax adjustments, or what is sometimes called BCA's, border carbon adjustments. And the European Union has put out an interesting, and in fact, maybe might be said courageous proposal that it's implementing. We know that these BCAs raise problems under GATT Article 1, 2, 3, and 11. That is the MFN rule of GATT Article 1, the tariff binding rule of GATT Article 2, the national treatment rule of GATT Article 3, and the quantitative restrictions rule of GATT Article 11. Depending on how they're structured, they do raise these important problems affecting fundamental free trade obligations. But we also know that in GATT Article 20, B and G, which of course are introduced with a chapeau, the BCA schemes may be defensible. Well, what role is trade going to play in addressing climate change, given the strictures and the defenses in GATT going forward? And we're going to see renewed emphasis on that with the Biden administration, which of course in its first 100 days has issued several executive orders, including rejoining the Paris Agreement, and is now, with former Secretary of State Kerry, working with India on a possible zero carbon emissions target. And finally, the fifth challenge, again for the Indo-Pacific region, but with implications for the whole world. And that is almost a theoretical challenge. Do we really believe in free trade anymore? We all know the classical and neoclassical theories, the classical ones articulated by Adam Smith with the law of absolute advantage and with David Ricardo, comparative advantage. And at least through most of the post-Second World War period, we tended to believe in those laws of absolute and comparative advantage. We tended to believe that lowering trade barriers was indeed beneficial in a net sense for a society. And we even have a much empirical evidence to show that doing so does stimulate growth. There are many studies from Ann Kruger, from the World Bank, from David Dollar, that all show in much of the post-Second World War period, trade did indeed stimulate increase in per capita GDP. We also got some evidence that, albeit with growing inequality, depending on complementary policies, trade could help alleviate poverty. But now we don't seem to believe that anymore. And going back to those linkages, we feel that, or do we feel that trade is undermining our national security? We cannot rely on supply chains for personal protective equipment or vaccines. We have to have domestic supply chains, or at least supply chains with just a few countries. And we can't see trade as advancing social interests, so we close up the boundaries. So it's a sort of theoretical challenge for us. How do we feel about trade and interdependence? As President Clinton would say, drawing his hands together, that trade and interdependence makes us all better off in an immediate economic sense and in a more broad social and security sense. Well, with those challenges laid out, and with this linkage among trade and national security and DEI and public health spelled out, let me again thank you all very, very much for this opportunity. And I'm very happy after the next speaker to address any questions or comments that you have. And thank you again to all of the organizers and all of you here for participating.
Thank you so much, sir. It was a really insightful session. I would request you to please stay logged in till Dr. Peter finishes his address. So I would like to welcome our next guest of honor today, who's Professor Dr. Peter van Bossche. He is currently the Director of Studies at the World Trade Institute and a professor at University of Bern. He is also a serving president of the Society of International Economic Law since 2018. He is the editor of the World Trade Review, Cambridge University Press. Dr. Bossche was also a member of the appellate body of the World Trade Organization, and he's even served as the chairperson of the appellate body in 2015. He's an honorary member of the Maastricht University, Netherlands, and he's a visiting professor of multiple universities. One of them is University of Geneva. And he's also authored multiple books on World Trade Organization. It's truly an honor to have you here, sir. I request you to please address the gathering today.
Thank you very much for this most kind invitation. And thank you to the organizers of the School of Legal Studies for inviting me to give this inaugural address. I'm honored by this invitation. I would also like to congratulate the organizers for putting together such an interesting program. And it is with much regret that unfortunately I'm teaching tomorrow. Teaching on a Saturday. Europe is changing in that way too. I'll be teaching and unfortunately not be able to join you, but you have organizers have put together a most interesting program. Congratulations. At this point, I would like to share my screen. So if the host allows me to do so, then can the host allow me to share my screen? Yeah. Okay.
So we also have your PPT. So should we share the PPT? Or or you've also been made the co-host, so you can also share your PPT if you like, if you would like that.
Okay. But I think here we are.
Yeah, we can see the PPT.
Okay. I will keep it short. I promise. I only have 3 slides. Yeah, after this introduction, so don't panic that I will give a lengthy and very elaborate lecture. But I would like to share with you some thoughts on the state of the multilateral trading system today, and what to expect, or perhaps hope for, in the coming months, in the coming years. And when we talk about anything these days, we think about COVID-19. And so the first thing that I think we have to address is what has been the impact of COVID-19 on the multilateral trading system. The impact has been profound. And it has been profound both in quantitative terms, and I'll say a bit more about that in a moment, but it also has been profound in many other ways. And one way Professor Bhala already referred to, it made quite a number of people wonder about the benefits of trade, the benefits of international trade, and the dependency that all of a sudden became quite clear on imports that no longer arrive. So I think that the COVID-19 pandemic has had a profound impact in that way. And it also had a profound impact, and now I'm talking about myself, in the sense that I now do my shopping online. I attend conferences like this one online. I teach online. Tomorrow I'll be teaching online. And I even transformed my guest bedroom into a home office. And I do realize that I'm among the fortunate ones that have a guest bedroom to transform into an office, and they do not have to transform their kitchen desk, the kitchen table, into an office desk. But these things have all changed. And I think to a large extent, these changes will stay with us. And they will have, each of these things that I mentioned, will have also an impact and influence on trade. Now, to come back to the less subjective aspects of the impact of the COVID-19 crisis, it obviously has had a very significant impact on world gross domestic product. The latest numbers from the IMF are that world GDP has gone down in 2020 by 3.8%. 3.8%. Now, in a way, that is much less than feared, because many of you will remember that the IMF in June of last year predicted that world GDP would go down by 6.1%. And even as recent as October, they predicted that it would go down by 4.7%. Now, GDP going down by 3.8% is still quite an impact. Let's not minimize this or minimalize this. But the impact in that respect has been less than feared. If we look at trade, and let me look at trade in goods. The latest figures, the latest numbers from the WTO are that trade in goods went down, and now we're taking volume terms, went down by 5.3% in 2020. But many of you will remember that there were much worse predictions in the course of 2020. In June, it was still expected that world trade in goods would go down by 13%. And as late as October, the estimate was 9%. Apparently, it will only be, or it has only been 5.3% in 2020. Bad enough, but less than feared. Now, looking forward, one expects a rather quick recovery. Looking back at the IMF numbers, world GDP is expected to go up by 6% in 2021, so this year. And the WTO expects that trade in goods will go up by 8% this year. But that's good news. Well, to some extent, because this expected recovery, or the recovery from the COVID-19 pandemic, will be quite uneven. The IMF, in a report that came out last week, said that advanced economies will emerge from the COVID crisis with little lasting damage, and they will recover quickly. But that is not true for emerging economies, except China. There, the fear is that it will take a much longer time to recover from the COVID-19 crisis. Have we learned any lessons from the COVID-19 pandemic? Well, I hope so. What I do see is that many companies that trade internationally, that are dependent on supply of inputs from abroad, that they have been diversifying their supply chains. And I think that's a very welcome development. In the beginning of the COVID crisis, there were those that predicted that global and regional supply chains would collapse and would disappear. That, of course, was nonsense. But there has been a realization that you have to have diversified supply chains. So I think that's what we also have seen is an increased awareness. That's positive, and I hope that one will act upon that and come back to that a bit later. An increased awareness of the need for different rules on trade in times of pandemic. We have rules, but these rules actually led to more trade restrictions and then to a liberalization that would have been very welcome and useful. But really, the message that I want to pass on is that the COVID-19 pandemic is not, and definitely will not, be the most important challenge to the multilateral trading system. There are much larger challenges, much larger challenges to the multilateral trading system. And Professor Bhala already referred to a number of them. First of all, and I'm going to give you three main challenges, larger challenges. There may be more, and we may debate on this, but I'm going to give you three. And the most important one for me is, it relates to the biggest challenge our generation is facing and the future generation will be facing, namely climate change. Climate change and more broadly, the environmental sustainability of economic development. That is a much, much larger challenge to the multilateral trading system than the COVID-19 crisis. Now, why is it a challenge? Well, countries are now gearing up, they're moving forward to take action against climate change, and that's a good thing. But they often also use trade instruments to do so. And something that comes immediately to mind, and Professor Bhala already referred to it, are of course carbon border adjustment mechanisms. The European Union has one in mind, Canada has one in mind, other countries have it in mind. But this sort of measure will lead to major disputes, endangering the multilateral trading system. Another enormous challenge to the multilateral trading system is income disparity. Income disparity and broader the social sustainability of economic development. For me, the growing income disparity, the fact that there are many people within our countries that do not fully benefit from international trade, from globalization, that have been the losers. That, to a large extent, explains the rise of populist politicians, of anti-globalism, of economic nationalism. And obviously, these three things that I just mentioned are threatening the multilateral trading system. And then finally, and there are those that would put this on top of the list, and perhaps I would, some days I would do the same. A very, very large challenge to the multilateral trading system, and again, Professor Bhala already referred to it, a very large challenge, an existential challenge, is the superpower geopolitical confrontation between the United States and China. And this is a conflict in which no country can be neutral. Yeah? We will all have to take side one way or the other. And let me note in this context the following. Note the following. China is the largest goods trading partner for 64 countries. The United States is the largest trading partner for 38 countries. Think about that. Think about which side countries will take in this conflict. Now, before I let's look forward now. Let's before we get too pessimistic and all this. The good news, there is some good news. The good news is that there is broad recognition of the need for reform. There has never, in my experience with the multilateral trading system, and I've been following it and studying it since my years on the John Jackson at Michigan University. I've been following it for 35 years. There has never been so much talk about reform of the multilateral trading system as there have been in the last couple of years, and that's very positive. Now, the problem is that there's a lot of talk about reform, but there is not that much agreement on what needs to be reformed and how it needs to be reformed, and which direction that reform should go. there is little agreement on that, except for perhaps at a very general level, the sort of areas in which reform of the substantive rules of the multilateral trading system are needed. I think that most, and one can underline here most, implying not all, but most. Most WTO members would agree that we have to update our rule book to 21st century problems. The problems that the International Trading Community faces now. Meaning that we need to reform the substantive rules of the multilateral trading system to address what? To address the clash between market capitalist economies and state capitalist economies. I think it's very naive, and I'm sure nobody is naive in this audience, but it's very naive to think that state capitalism will sort of wither away, will disappear. It is there to stay, and it has proven in some contexts to be quite successful as a development model. So state capitalism is there to stay. The question is, can the multilateral trading system accommodate state capitalist economies and their operation within an international trading system? So that's a challenge to be faced, and that challenge we're talking about industrial subsidies, we're talking about state-owned enterprises, we're talking about that sort of thing that from which we need new adapted substantive rules. Secondly, we need a reform of the substantive rules to address climate change and environmental degradation. Environmental degradation, going to air pollution, soil pollution, loss of diversity. I don't have to clarify the need for rules to address climate change. Third, new substantive rules to address poverty and economic inequality, both between and within countries. There are still too many countries that do not sufficiently benefit from the multilateral trading system. There are developing countries that have done very, very well. Emerging economies that have done very, very well. But there are also others. And within countries, and that goes both for developed and developing countries, and I already referred to that before, the income inequality proportions that are not sustainable. We need new rules to address the digitalization of trade. E-commerce has taken off tremendously in these last couple of years. And our rule book does not provide for effective solutions to many of the problems that are occurring in this context, because they're new problems. It's a new way of trading, and so we need to address that. And of course, here the e-commerce negotiations are important. And I've always been surprised, and in the audience, good friends of mine know this. I've been surprised about India's attitude to these negotiations. I think that's perhaps something that we can elaborate when there are questions about it. Fifth area where I think that there is a consensus that something needs to be done. That's not to say that there is a consensus on what needs to be done, but that something needs to be done, is the politicization, that's a difficult word, or weaponization of trade policy. And here I'm referring to two things. First, I'm referring to the proliferation of the invocation of national security as a justification for trade restrictive measures. And it's not only the United States that has been guilty on this. I'm referring to that. But I'm also referring to the use of trade in order to promote values that you hold very dear. For example, human rights. Professor Bhala referred to it. And should it not be possible, or should there not be more leeway to use trade in that sense? And then finally, that is of course COVID related, new substantive rules on the role of trade in responding to pandemics and other calamities. I think we should not. Now, in all this, I think it's important that we look at what happens at the regional level, what happens in regional trade agreements. Interesting things are happening there, and some of these things may hopefully eventually be multilateralized at the global level. Apart from reform of substantive rules, there's definitely also a need, and that is also recognized, again, by most, not all, the reform of the institutions, the procedures, the practices of the multilateral trading systems. Reform that is needed to allow for or to revive negotiations on new trade rules, the new trade rules that we've discussed a moment ago. They need to be negotiated, but how? How do you do that? Multilaterally, plurilaterally? And in this context, I note that India has been very hesitant, very critical on the plurilateral negotiations that take place in the context of the WTO. And I can understand the fear that is behind this, but how realistic is it to have multilateral negotiations on many issues in the next coming years? Should that mean that there should be no negotiations at all, not even the coalition of the willing? But I do, of course, hope that the results of these negotiations will be applicable on a most favored nation basis, because if not, then these plurilateral negotiations may be the beginning of the end of the multilateral trading system. What we also need, and you wouldn't have expected me to say anything else, we need reform in order to ensure that we will have independent, impartial, rules-based, two-stage settlement of trade disputes. And on that, I'm still not sure that I know where the United States stands. Last slide. What are the short-term prospects for reform? Well, first of all, let's look briefly at some current developments. And with current developments, I mean things that have been happening over the last couple of months. I cannot but be very happy to see the sort of fresh sense of purpose that DG Ngozi has injected in the WTO. I had expected much of her, but she gave more. Now, it's still to be seen whether it will go anywhere, because the powers of a DG of the WTO are limited. But there is a fresh wind, if that is a proper English expression, that within the organization, and I hope this is shared by all of you. That feeling. What is also positive is the reported progress, and I put progress here between inverted commas because everything is, of course, relative. In the ongoing negotiations, negotiations on fishery subsidies, we're still far apart. Not we, negotiators are still far apart on crucial issues, but there seems to be progress. Progress in the e-commerce negotiations. Again, full agreement is not for tomorrow, but the negotiating and the negotiations don't break down. And these days, that's already something to be happy about. The investment facilitation negotiations. These are negotiations which probably do not get the attention that they deserve. They're perhaps less sexy, but I think they're worth looking at. And finally, well, it's not a complete list, but the last one that I'm going to mention are the domestic regulation for trade in services negotiations. So in these 4 negotiations, there is reported progress. There's also, this needs to be mentioned, there's also the restart, the intended restart of the environmental goods negotiations with a possible expansion to environmental services. This is also positive. Third point, there has been in recent months, there has been the initiation of what is being called structured dialogues, informal structured dialogues. You can always count on WTO diplomats to come up with new words in order to sort of mask what they're actually doing. These are discussions / negotiations. Well, they don't want to call them negotiations yet. Discussions, dialogues. Dialogues on what? Well, on what I think to be important things for the WTO. A dialogue on plastic pollution. We all know how damaging plastic waste is to our environment. So WTO has very, very carefully started dialogues, and currently still a limited group of WTO members that participates, but there's no reason why this group should not become bigger and bigger and bigger. And the other very important dialogue that was started is a dialogue on fossil fuel subsidies. Yeah. Right. What else happened over the last couple of months? Well, changes, and again, I put this in inverted commas for a reason, in the trade policy of the US and the EU. And let me perhaps first say something about the change in trade policy of the EU. For those of you who would not yet have read the February 2021 communication of the Commission, European Commission, on its new trade policy, please do. Yeah, it's a very interesting document. It has a bit of a misleading first half of the title. It talks about trade policy review. Yeah. So it's not trade policy review in the WTO sense of the word. It's a review by the European Commission of the EU trade policy. But what's interesting, and which tells us a lot about that document, is what follows. What follows, and the rest of the title goes. It's on an open, sustainable, and assertive trade policy. Open, sustainable, and assertive. And I always underline the word assertive. because it sort of signals, the European Commission signals to the rest of the world, and actually that's what's in the communication, that they will use trade policy in order to promote European values. Yeah. That goes also a bit back to what Professor Bhala has said about human rights, like US trade policy. And obviously I'm more careful to talk about that in the presence of Professor Bhala. But let me say the following. Obviously, the Biden administration is much more multilateral inclined, yeah, and they've already shown that in the context of the climate change context. And yes, they reach out more to traditional allies, but on trade policy, to be honest, I think that the current trade policy resembles very much the Trump trade policy. If you think about the relation with China, it's very conflictual. The invocation of national security, there's still no solution in sight for the US steel and aluminium dispute, and their continued attitude with regard to dispute settlement and the appellate body. There are, of course, many other developments that I could pick out here, but let me perhaps focus as a last point on something that some of you may have missed, and that is now, in April 2021, it's not only the appellate body that is paralyzed, also the dispute settlement body is now paralyzed. And this as a result of the United States' refusal to adopt the agenda of the meeting, the last dispute settlement body meeting. Why did they refuse to adopt the agenda? Something that has to happen by consent, according to WTO practice. Why have they refused to adopt the agenda? Because one point on the agenda was the establishment of a panel against the United States, a panel requested by Venezuela. And the United States argues that the government the Venezuelan government that requested the establishment of this panel was not the legitimate government, and therefore they could not accept the agenda that had such a point on it. As a result, the DSB meeting has been suspended and will remain suspended until this dispute is overcome. We've had something similar happening in 2019. Then, after some time, Venezuela caved in and they withdrew their request for panel establishment. The world has moved on since, and I'm afraid that we're now facing a much longer crisis. And perhaps the United States doesn't really mind, even under the Biden administration, doesn't really mind that the whole WTO dispute settlement system is non-functional, because that would strengthen their hand in negotiations on a new system. Let me conclude by looking forward a little bit and tell you something about the possible deliverables for the next ministerial conference at the end of this year. Then first of all, I would like to say that I completely agree with DG and Ngozi that we should be realistic in our expectations and not overload the program, not yeah, not expect too much, because then we'll all be disappointed. So what do I think might be, or should I say rather, what do I hope, not think, what do I hope are deliverables? Well, a framework agreement of fishery subsidies. And I've added myself the word framework agreement, yeah, because I don't think we'll get more than that. Yeah? But we should get at least such a framework agreement. We'll still have many holes and things that need to be discussed and decided later. But without at least such a framework agreement, the embarrassment for the WTO would be tremendous. Yeah? If they can't even. Now, I know, and certainly in India, people are very much aware that the positions between the negotiators are still very much apart. Yeah? And that is primarily, but not only, on what sort of special and differential treatment should there be for developing countries regarding the disciplines under disagreement. What else could be a deliverable? Well, something on trade and health. A declaration, a decision, trade and health. Well, that would talk about, I hope, vaccine nationalism. That would talk about the role of trade in the economic recovery from the COVID-19 crisis. And that would then be more in the line of the Ottawa Group initiative to focus on protecting supply chains in times of pandemics. Perhaps some of you say, hey, you're forgetting the waiver, the TRIPS waiver. I think to the extent that that makes any chance, it will be in the context of addressing the problem of vaccine nationalism. What else? And I'm becoming less and less optimistic. The restoration of a two-stage dispute settlement system, or in other words, to break the deadlock on appointment of appellate body judges. If I were a betting man, which I'm not, but if I were a betting man, I wouldn't put any money on that one. Yeah? I think fixing the dispute settlement system in a way that gets you a system that is worth having, yeah? That is impartial, that is independent, that is two-stage, that is rules-based, a system that is worth having. I think this will take much longer. And then finally, I think what we will see are a number of roadmaps for other negotiations on e-commerce. Yeah? There's a small chance, there's a small possibility that there may be small agreements already on very specific issues. I understand that there is actually an agreement now among the negotiators on spam. I would actually welcome such an agreement because I'm often the victim of spam. E-commerce, a roadmap for the negotiations on e-commerce, a roadmap for negotiations on agriculture, domestic support measures, but public stock holding also, an issue of interest to India. Roadmap for the negotiations on investment facilitation, on domestic regulation of trade in services, on environmental issues, such as an issue that Professor Bhala also referred to on carbon border adjustments. Now, there will not be a solution to this problem in the next ministerial, but at least one would hope that there's a roadmap for future negotiations. A roadmap for future negotiations on industrial subsidies, and finally, negotiations on special and differential treatment, because I was very happy to see the proposal by the G90 on special and differential treatment, the proposal that was made in February 2021. Let me conclude. There is much, much hard and difficult work ahead. But there is no alternative than to face that workload, than to face the challenges that the multilateral trading system will encounter. Because a world without an effective multilateral trading system would not be a very pleasant, safe world to live in. Not for you, not for me, not for everybody. Thank you.
Thank you so much, sir, for such an interesting session. The floor is now open for the Q&A session. The question and answer session will be moderated by Professor Shivani Rajesh. That there's a link that has been sent to all of you, all the participants, to put their attendance in it. So please fill in the Google form and send it before the session ends. I would like to request Professor Shivani to please come and start the question and answer session. Thank you.
Thank you so much, Mithike. Good evening, everyone. My name is Shivani Rajesh. I would first like to start with talking about how it is an absolute privilege for all of us here to be hosting Professor Bhala and Professor Vanden Bossche, two of the most important academicians in the international trade law field. Thank you so much for attending this and for addressing our participants. We will start with a question and answer session. We have quite a few questions pouring in. One of the relevant ones that I can find out here is for Professor Vanden Bossche. Tamanna asks, although digitalization is one of the major reforms taking place at the WTO level, will it not put the developing countries at a disadvantage due to the glaring digital divide?
Am I going to answer the questions immediately, or shall we gather a few questions? I'm in your hands. I'm happy to answer the question on digitalization.
You may go ahead.
I'll start. Yes, yeah. There is such a thing as a digital gap, which, by the way, does not only in developing countries, between developed and developing countries, it also is a reality in developed countries, this digital gap. And it's a very worrisome thing because those that are on the wrong side of the gap, they suffer. Huh? So I would start by recognizing this digital. But I don't think you address that reality by not engaging in negotiations on what the rules of digital trade should be. I think you should engage in these negotiations, if only to make sure that these rules do not worsen and ideally lessen the digital divide, the digital gap. Yeah? So that's the best answer that I can give. Now, I recognize the reality of the divide, of the gap, but the way forward is not to say, well, we don't even want to talk about possible rules. It doesn't show much confidence in one's negotiating skills. Anyway, even if you engage in these negotiations, you don't have to then at the end sign up to whatever comes out of these negotiations. You can say, well, no, that's not what we want. We did our very best. But in my personal opinion, and I'm not engaged in these negotiations directly, so I should be careful what I say, but in my personal opinion, the voice of countries that are not engaging in this, such as India, that voice is now missing around the negotiating table. That is not heard.
Thank you so much, Professor. The next question is for Professor Bhala. As mentioned earlier in your speech, the theories of absolute advantage and comparative advantage were relied upon in order to develop international trade agreements. However, now we are moving away from pure economic theories and including non-trade issues while concluding trade agreements. Is it that this change in approach is making it difficult to negotiate agreements at a multilateral level?
Well, thank you for the question. Just one quick follow-up on the previous question. I think we have a very good model on digital trade that was negotiated by countries at various stages of development, from Vietnam and Peru to Singapore and the United States and middle-income countries such as Malaysia. And that's the Trans-Pacific Partnership. If you look carefully at the provisions on digital trade in the TPP, you'll see coverage of all of the key issues, including data localization and data privacy and technology backdoors. And these were negotiated by countries that indeed face the digital divide, either internationally or domestically or both. On the question about theory, that's a great question. You know, let me start with a quote from Shakespeare, and then I'll explain why I use that quote. He says in King Henry IV, part 2, when Hotspur is killed by Prince Henry, Hotspur is dying, and he says, life is thought's slave. Life is thought's slave. Time is life's fool, and then time spent surveying life, it must come to an end. Well, it's the first of those three clauses that's the key. Life is thought's slave. And what I mean by that is, I was educated in the 1980s in economics and law in the heyday of the classical and neoclassical economic models in favor of free trade. And of course, we saw into the 1990s, after the fall of the Berlin Wall, the so-called Washington Consensus around trade liberalization. So to some extent, my thinking, you know, I am this, my thought about trade is a prisoner of, or the slave of, the time in which I grew up and was educated. And so that theory still resonates very much in my mind. And I'm very much of the view, as my law professor said, that it is always the burden on the government to show why it is intervening. Otherwise, the marketplace should be allowed to function freely. The burden of proof's on the government, and that includes interventions with respect to trade. Now, recognizing, and this gets to the other next parts of Shakespeare's quote about time being life's fool and time spent surveying life must come to an end. Well, in fact, in surveying life, now we must bring to an end our discussion about the use of neoclassical economic models, because it's over. That is to say that those models are not roundly accepted anymore. And so as the question gets to, and as I'm entirely agreeing with, yes, the change in the views of the theory has impeded trade negotiations. I mean, we are not in the theoretical era where everyone basically shared some version of the Ricardo Smith paradigm, as we were in 1986 to 1994 in negotiating the Uruguay round, or the late 80s through early 90s in negotiating NAFTA 1.0. So when we're operating from very different theoretical premises, it becomes harder to reach what in WTO speak is that magical landing zone, where you get some kind of grand bargain that bring countries together on a consensus. That's why I again go back to the TPP is the best example we have, albeit a second best solution, of a diverse array of countries with different paradigms, operating in different theoretical paradigms. I mean, it's kind of hard to get a lot different from Brunei on the one hand to Vietnam on the other hand, and then toss in the likes of the United States and Canada. to come together. Let me stop there, but I hope that addresses the question.
Thank you so much, Professor. Anything you would want to add, Professor Van den Bossche?
No, I couldn't. I completely agree. And I think it also goes back to the question that I tried to put on the table. Can the multilateral trading system, as it has been devised, and as Professor Bhala and myself have been trained in it, can that accommodate quite different economic systems, which have always been around? I mean, there were some not socialist, but communist members or contracting parties of the GATT, but they were of minor importance. Yeah, China joined the WTO. We were all, I think, all of us, we thought that by China joining the WTO, China would become more like us, whatever that is. But anyway, it would become more like us, and we were all proven wrong. China has not become more like us. China has continued to be more like itself. It's a state capitalist system. Now, is there room for such a system, an economic system, within the multilateral trading system? I think there is, but it will require us to modify the current system. So it's
Thank you so much. Just in extension to what you just said, Professor Van den Bossche, I think the countries are trying to use an alternative method in order to accommodate all the economic systems. And that alternative method is probably engaging in negotiations with respect to free trade agreements or FTAs, which is at a rise. And that is equally affecting the functioning of the WTO as well, because most of the provisions of the FTAs and the WTO are either overlapping or they are contradictory, which makes it very confusing. Would you like to say something as to what can be done in order to deal with this problem of rising FTAs?
I very deliberately did not list that as a major challenge to the multilateral trading system, but exactly to provoke this sort of, and I'm very happy with the question or the comment, exactly to provoke this. In my mind, the proliferation of regional trade agreements is not in itself a major challenge to the multilateral trading system. And I know that I'm contradicting here many other more knowledgeable people. But for me, we have to see it as stepping stones. Yeah. Because nobody is really happy to be just in their regional trade agreement. Everybody hopes that there will be rules at the multilateral trading, at the multilateral level. There are actually many problems that cannot be efficiently addressed in regional trade agreements. So I think for nobody, it is sort of the end game. But it's better than nothing. And that's the whole philosophy behind Article 24 of the GATT and Article 5 of the GATT. It's better than nothing, and they're stepping stones. So I'm very happy that it's observed that I did not mention that under the major challenges. No, but what I did say, and perhaps I should have explicitly included in my slide, what I did say is that when we look at the substantive challenges, the areas in which new rules are needed, that what happens at the regional level is something to look at and see whether these things can be multilateralized. And the more regional trade agreements we have, and the more overlapping there is between these regional trade agreements, the easier it becomes to multilateralize some of these rules.
Great. So thank you so much. Professor Raj Bhala, anything you want to add?
I agree entirely. I agree entirely. In fact, there's empirical evidence in favor of the idea that free trade agreements can be stepping stones. The provisions on intellectual property and on trade and services in NAFTA 1.0 were the stepping stones for the negotiating positions of the NAFTA parties in the Uruguay round that helped lead to the TRIPS agreement and the GATS. And then conversely, as we've seen agreements in the WTO years ago now on, say, information technology or on government procurement, those in turn have helped drive chapters on government procurement and on information technology in free trade agreements. The only caveat I would mention in terms of the proposition that the sheer number of FTAs is not a threat to the multilateral trading system, and it's a small caveat, is that, and this is especially appropriate in front of law students, free trade agreements are great work for lawyers because of their rules of origin. We see this at Dentons all the time, where clients come to us and say, what are those rules on lithium batteries? Or what are those rules on a particular farm commodity? We happen to be exporting to countries that are in multiple FTAs, and we want to satisfy the rules of origin. For those of you who are technically inclined in law, I encourage you to learn well the way rules of origin work in FTAs. So it's a plus for our legal profession, put it that way.
Thank you so much, Professor Bhala. To conclude, I would like to, I'm made to know that Professor Sandeepa Bhatt wants to ask a question as well. To give a little bit of an introduction, Professor Sandeepa Bhatt is a professor at NUJS, Kolkata, and without him, this conference would not have been possible at all. So you may go ahead and ask your question.
Thank you, Shivani. I should first of all thank both Professor Raj Bhala and Professor Peter von Bossche for accepting my invitation. And I should also say, both of you, that in any Indian universities, whatever I have gone across actually, I have seen both of your books as the major treatise for the purpose of studying international trade law, right? So be it actually your modern GATT law, Professor Raj Bhala, or maybe be it actually the law and policy of the World Trade Organization by Professor Peter von Bossche. So these are the two major books for reference in every university in India, whatever I have visited till today, right? Including my own university wherein I teach international trade law. I think probably this is one of the special occasions wherein we have both of you as the part of this particular inaugural session. And I should be really glad to see both of you, and as well as your enriching speech about the topics, whatever you have already spoken of. Let me have two quick questions. Of course, maybe, I mean, time is, we are not having too much of a time here. So let me actually ask you the two quick questions. Even though I have multiple questions in international trade law, I'm still learning many aspects of that. First, I think Professor Peter von Bossche has already referred to the negotiations, especially the progress in terms of the digital trade negotiations, or maybe e-commerce negotiations and all those things. Is there anything apart from TPP which is also going on, and at what level it is there actually, especially in terms of the digital trade negotiations? At what level negotiations are there? How much of actually the liberalization has taken place in terms of the digital trade? That is one thing which I would like to know. Second thing is about the WTO dispute settlement mechanism. As has already been discussed, we have a paralyzed WTO appellate body, and the interim arrangement has also been done in terms of the arbitration appeal. But I'm not very sure how far it is successful. It's just actually a limited number of states who have become parties to that. So I would like to know about actually the possible success of the interim arrangement. Plus, also more importantly, can we look forward for the non-adversarial dispute settlement mechanisms like maybe mediation, conciliation, and good officers, which we are having under Article 4? Can we strengthen that so that the WTO dispute settlement mechanism can function smoothly in the future?
I suppose you're provoking me on the dispute settlement question. With permission of Professor Bhala, let me address that one. Yes, I did not refer to the MPIA, so the multi-party interim appeals arbitration mechanism. This is not because I don't think it's useful. It may be useful. It remains to be seen whether it's going to be useful, because it has not been used yet. There are now, to my knowledge, 24, 25 WTO members that have joined the arrangement. I'm never quite sure about this, because the WTO website is not very cooperative on communicating on the MPIA, which tells you a story. Let me not further develop that idea, the arbitrators, the 10 of them, are, this is not secret information, they are e-meeting, so digitally meeting, apparently every week to discuss the procedures that they will follow. And there's a lot to be discussed. There's some hope or some expectation that later this year, the first cases will come to this system. I do not expect that there will be many cases, but there will be some, and all disputes that can be resolved in this way are resolved. That's a good thing. Now, on the second part of your question, will there be more scope for, or will there be more use made of the what has been referred to as alternative dispute resolution? It's more diplomatic dispute resolution, good offices, conciliation, mediation. Very little use, and that was 3 times very, has been made of this possibility until now. Yeah, and I think for good reason. I don't think that Article 4 processes will now fill the gap that is left by a non-functional dispute settlement system. And by the way, it's, I've already said before, the appellate body is paralyzed. And when that started happening, there were too many in even the legal community, but certainly many among the ambassadors that said, oh, well, that's a pity, but we still have the panel process. Well, what is happening now? Every single panel report, with one exception, has been appealed into the void. So it's somewhere there in legal limbo. Of all the panel reports that have come out since December 2019, all but one has been appealed into the void. So it's the whole dispute settlement system that is endangered. Will good officers, conciliation, mediation fill the gap? No. I think what would be more interesting to look at is dispute settlement under regional trade agreements. Because many of these regional trade agreements have sometimes an even fairly sophisticated, not always, but certainly the new generation agreements have a very sophisticated dispute settlement system without any experience, without secretariat, without any means, but at least the system is there. For example, in the context of RCEP, we've all recently looked at this, what this dispute settlement system and the RCEP is. I think this will be more interesting to watch. Yeah? To which extent that we see disputes shifting from WTO dispute settlement, which is no longer available, or does not, shifting to dispute settlement under regional trade agreements. I wouldn't hold my breath, but it would be interesting to watch.
Well, let me just comment first on the very kind introduction that Dr. Bott gave us. I want to say that I always feel very much like a student in international trade, and it's funny, and this is really for all of the law students out there. Don't worry about feeling overwhelmed, because there is a lot to, and one never masters it. Or as someone who likes running a lot, there's no finish line. You just keep learning. On the question of the appellate body, I see you've got my dear friend and co-author, Professor David Gantz, tomorrow, and I heartily encourage you to hear what he has to say. I think he and I, we're enthusiastic champions of the appellate body, of the dispute settlement system, and we're honored to be here with Professor Van den Bossche. I mean, one of the great jurists in modern international law. Now, I want to source the problem of the blockage of the appellate body in the question of judicial interpretation and the peculiar U.S. approach to it. And I think those of you who study Indian constitutional law, which I'm sure is a required paper, will appreciate what I have to say. The Obama and the Trump administrations put out scathing reports about the appellate body, and they spoke about its use of obiter dicta, its view of stare decisis, its taking on issues that weren't in the pleadings, and so on. Now, I would like to suggest to you that the real problem lies in the peculiar way in which Americans, and here I'm not saying all Americans, but those who are involved in deciding who gets to get nominated to the appellate body and whether or not there'll be a consensus for an appellate body candidate, those officials, how they view judicial interpretation. And the specific question, which is Professor Van den Bossche well knows, because he's done it successfully so many times, is how do you interpret a word or phrase in a text, a treaty in this case, the GATT-WTO treaties, that's ambiguous? How do you interpret a word or phrase that is ambiguous? And you don't have a legislature, or as it were, the WTO General Council or Ministerial Conference giving you guidance. And there isn't time. You've got to make a decision. Now, the conventional approach is, of course, to use the Vienna Convention, Articles 31 and 32, and look at the ordinary meaning of a term, the lexicographic meaning, the Oxford English Dictionary meaning, and then look to the object and purpose. So then you go beyond the text itself to the context, and then you look also possibly at further means of interpretation, even beyond object and purpose. And just Article 31 and 32 tell you that there is more to treaty interpretation, if need be, to interpret in a peculiar term, than the meaning of the word itself according to a dictionary, because the dictionary itself may be ambiguous. Now, put that thought on one side. Now look at what we've seen in modern American history since the nomination of Robert Bork in about 1986 to the Supreme Court. What have we seen in American judicial interpretive thinking? That the only way, the exclusive way to properly interpret a text is to look only within the four corners of the text and look only at the meaning of the word and look at the dictionary meaning of that word, and preferably the dictionary that was used at the time of the founding fathers when the Constitution was drafted, the original intent. That's known as textualism and specifically originalism. Now, I've talked with justices in many Supreme Courts, India, Israel, etc. Nobody believes that original intent is the only way to interpret a text. However, now let's put these two thoughts together. When the United States comes to decide who's going to succeed Professor Vanden Bossche, or who's going to succeed whoever is Ujjal Singh Bhatia on the appellate body, what they want to see is, are you going to be a strict textualist and look only at the meaning of the word, probably use the version of the OED that came out during the Uruguay round? Now, that is an incredibly narrow-minded way, and ultimately to look at text, and ultimately it reifies the text. It turns them into wood. It doesn't allow them to live and breathe freely as the trade world evolves and new issues like e-commerce come on. Now, we teach, and it's really a fun class, law and literature at the University of Kansas. And we go through 10 different ways that texts can be interpreted. Legal methodologies and methodologies from our friends who study English literature also use. And once one starts opening one's mind and sees that legal text is a species of literature and is subject to 10 different ways of interpreting, then you see that the exportation by the United States of its peculiar narrow-minded judicial philosophy to the appellate body is really what is ultimately blocking on the consensus. Now, this way of interpreting you do not see in the jurisprudence of the Indian Supreme Court. It's a much more broader way of looking at texts. And all of it is consistent. All these different methodologies are consistent with the straight meaning of terms of the Vienna Convention. So I think, and I don't want to sound professorial about this, but I think part of an important key to unlocking the blockage at the appellate body is to have a good, honest discussion of what do we mean by judicial interpretation and what are the acceptable methodologies that work across legal cultures, Anglo-American, civil, and Islamic. Thank you.
Thank you so much, Professor.
Thank you so much. If you have any quick comment on the digital trade, I would definitely appreciate on that as well. The progress in terms of digital trade negotiations.
Could I just make one remark on what Professor Bhala just very, very well explained, and I'm also grateful for his continuous support for dispute settlement, rules-based dispute settlement, and the appellate body. It's well noted. I agree with everything that Professor Bhala said, but I would add to this that the United States has, in its criticism of the way in which the appellate body has interpreted provisions, the United States has not been consistent. Yeah. And let me just refer to one case, one out of many. The China Publications and Audiovisual Products case, in which the appellate body took an evolutionary interpretation of China's commitments under the services schedule. Now, mark the words, an evolutionary interpretation. Did the United States complain about this case? No, because they won it. Yeah. The United States has been very, very, very selective in the appellate body reports and interpretation methods it has criticized, and of which he had said that it constitutes judicial activism, overreach, and those it has not criticized. They have not criticized those interpretations, sometimes daring interpretations, sometimes interpretations that went against the whole membership. Think about amicus curiae briefs, and the appellate body allowing amicus curiae briefs. This was the appellate body, the United States, against the rest of the world. And yet, that was quite innovative. Think about, of course, these are procedural issues, but they're important ones. Think about opening appellate body hearings for public observation, also at the demand of the United States and the European Union. All developing countries said, no, you can't do that. Article 17, paragraph 10 explicitly states that appellate body proceedings are confidential. The appellate body found a way around this provision by referring to, very inventive, by referring to Article 18.1 of 18 of so please, this is, but thank you for allowing me to vent my frustration.
And even maybe the shrimp turtle case itself, initially the evolutionary interpretation of exhaustible natural resources, probably there was the United States itself which argued with respect to that as a first country to go for the evolutionary interpretation.
I'm not, if there was a question there, I'm not sure whether I got it. The connection was not optimal.
Okay, so I have another question with respect to the digital trade. I just asked you what kind of progress which is going on with respect to digital trade apart from TPP.
Oh, this would be a lecture in its own right. But there are a number of technical issues on which there seems to be more of an emerging consensus, and I did refer to spam. Yeah, I think the same goes for digital signatures. And with that, you could say, well, is that important? Yes, it is very important. If you trade over the internet, digital signatures may be important. But I mean, for a number of the more sensitive issues, such as how do you protect and to what extent do you protect privacy, or to what extent you protect national security, and immediately you see China versus the European Union, the US, on these two issues, very different positions. There's still a lot of work to be done, but at least they're talking, and it's a pity that India is not on that negotiating table.
I would just add that towards the end of the Trump administration, the United States signed a digital trade agreement with Japan. And that was actually one of our first bilaterals that focused just on digital trade. And so that's available on the US Trade Representative's website. And that might be of interest to study. I confess I'm not an expert on its terms. And I would also point out, and this is maybe going forward, indirectly related to your question, the president's trade negotiating authority expires on July 1st. And I would encourage all of us to watch whether or not we see the Biden administration submit to Congress trade negotiating authority renewal. Right now, I'm wondering whether the president will actually seek that negotiating authority to be renewed after July 1st, because we've got, of course, the infrastructure bill going through Congress, and we've got relatedly digital services taxes issues, both with the OECD and Congress. And so we may see actually not a lot of movement on US trade deals, including deals involving e-commerce and digital trade for a good year or two, if the administration says we want to focus on more domestic issues and not look at trade negotiating authority, maybe until after the midterm elections. So that's sort of something to watch in terms of what's going on Capitol Hill.
Thank you so much, Professor. I think the last 20 minutes was personally one of the most informative discussions that I have heard between the three of you. So thank you so much. With this, we are done with the question answer session. I would like to call upon Rishvi once again to continue the program. Thank you so much.
Thank you. Thank you for the invitation, and good luck with the rest of the conference.
Thank you so much. Thank you so much for both of you.
I would like to thank Professor Shivani Rajesh for moderating that session. And since I am in the liberty with the microphone for a moment, I would like to personally and on behalf of the student community in the audience, express my gratitude to the dignitaries, Dr. Raj Bhala and Dr. Peter Van, for that absolutely insightful session. To move on, I deem it my privilege to now welcome our respected Dean, CMR School of Legal Studies, Dr. T.R. Subramanya, to deliver the presidential remarks for the event.
Oh, respected Dr. Praveen, Registrar of the University, Dr. Suja Bennett, Academic Dean of the University, Raj Bhala, Professor of Law at the Kansas University School of Law, Dr. Peter Van den Bossche, Director of Studies at the World Institute, University of Bern, Dr. Sandeep Bhavat, Dr. Professor V.G. Hegde for the School of International Studies, Jawaharlal Nehru University, and the respected resource persons, and all the learned participants and the paper presenters, teachers, and dear students of the CMR Law School and other law schools. We are privileged to have the most learned scholars on this occasion. At times, I was just looking back. I still remember in 1988, when the discussions or the formation of WTO was going on, lots of meetings used to take place in Delhi. I was just a PhD student at that time in Jawaharlal Nehru University, and these meetings would take place in Sapro Auditorium. And during the course of these meetings, there will be representatives from the ruling parties, there will be representatives from trade unions, and there will be representatives from communist parties and a host of other speakers from the academic community as well. So at that time, naturally, the discussion was limited to the establishing the WTO and the proposals and the discussions that have taken place or taking place from September 20th of 1986. That is the date wherein the first discussion began. And it concluded in the year 1994 on April 15th. But then each day the discussion was going on for almost, remember, 7 or 8 years till it was signed. And there were critics, and these critics always would go to the extent of pointing out that WTO is not going to serve the purpose. But then over a period of time, I still remember it has lived its purpose. But then the discussions which are taking place today is totally different from what we have witnessed during the formation of the WTO. Today we have fresh challenges. And these challenges were not visualized by the makers of WTO or the formation or the formative leaders who discussed threadbare most of the issues related to WTO. So this is an inhospitable situation. In an inhospitable situation, naturally, as the first speaker pointed out, we have plenty of challenges. And with these challenges, we'll ultimately resolve the issues by way of conclusion, by way of entering into a model treaty, which can be accepted or which may be accepted by all the members of the United Nations, at least 160 or 80, although we have 190 plus members of the United Nations. Now, the one issue happened to be the issues relating to national security. When I speak of the national security, you might be knowing the entire paradigm, or the better word is, in the chessboard of international politics, things have changed here. There were people who used to call themselves as superpowers. Now they have to believe in the doubting Thomases, saying that, is it true or it was earlier? Now, there are some people, some states who are claiming that they're the most powerful and would become the powerful and trying to twist the entire hegemonic role. Now, under these circumstances, what would be, what could be, and what should be the world trade? That is where Raj Bhala has correctly pointed out. One issue happened to be issue related to national security. That should be a compromise. The second issue happened to be public policy has to be changed. Now, when we change the public policy of which region, what government? Now, there are communists, and what is their public policy? And they will only think and speak about the welfare program. They will not believe or in improving the existing structures. That is again a problem, very difficult to compromise, and it will not lead to any conclusion. Now, the most important thing is, which was precisely said, happened to be inclusiveness. The World Trade Organization, the discussions which were taking place, I still remember, most of the people were not using the word inclusiveness at that time. All they did not use the word inclusiveness, they were only putting a question. Whether we are the poorest of the poor, whose per capita income then was less than $50, is going to be helped by this. If it is going to be helped, in what way? Where is the solution? Where is the documentation? They were asking the government then. And the government was not able to give a satisfactory answer because the discussion was inconclusive, because it could not complete it, they could not give. Now, thereafterwards, when the WTO came into force, remember, there were several issues which came up before the forum. I still remember. Now, one issue happened to be an issue relating to climate change. So, when the issue related to climate change, one of the National Law School professors just asked me to speak about on the art of negotiation. When they asked me to speak about the art of negotiation, I just thought of, remember, it is not enough if you give the meaning, but you have to give the practical illustration. Then I just tried through somebody from the Foreign Office, what type of discussions have taken place from the Ministry of External Affairs on climate change. Documentation he did not give, but then he can speak half an hour and I shall listen, that would be enough. Now, the documentation, when it was going on in the formative periods from 1996 to 2006, it is only a discussion, and the discussion was inconclusive. And they were not able to speak much about it. Being a developing country, African states also wanted to represent the state of India, their claims. So when they wanted to represent their claims, all of them were, remember, behind the state of India, India was supposed to be a leader. But then the Ministry of Environment at that time was trying to play the dynamic role, but there was no dynamism. And then from 2006 onwards, it started improving slowly. And the claim of the developing countries, especially the least developing countries, were taken up by the government of India. Now, that is why inclusiveness and matters pertaining to climate change are going to be the discussion, and they are going to be the pillars in the area of WTO whenever a treaty is going to be signed. Now, the other important aspect, which is again question, do we believe in free trade? The point at issue is, Free trade is very much essential. Perhaps there would not be an inaugural negotiation in 1994 if every state were to be satisfied with what was prevalent earlier. Just anybody, any participant can just think of it here. When the matter started, they were discussing only of trade in goods. Then came in trade in services. Then came in trade in intellectual property. Then several other things came in and the matter was resolved then and there. Same thing is going to happen when the discussion reopens in the event of COVID. So that is for sure, because many people are speaking about the changed equations in the present society. However, with all these things, now, as Dr. Peter Van den Bossche has pointed out, when we have a change, we should believe in structured dialogue. Unless we opt for a structured dialogue, it is just not possible to arrive at a compromise. So the structured dialogue must be open, as he has pointed out. It should be sustainable and it should be assertive. That is the message which we have learned from this seminar, from this discussion. I once again salute the two great speakers and the learned participants for listening thus far. Once again, with best wishes, thank you.
Thank you so much, sir, for your kind remarks. I would like to now invite Professor Srinidhi, the organizing secretary for the event, to deliver the vote of thanks.
Very good evening to one and all. It is at the outset, let me just say it's an absolute privilege for me to be up here this day proposing the vote of thanks at such in front of such an august gathering. Primarily, it would be my duty to thank Professor Raj Bhala for that extremely insightful session on the challenges facing the Indo-Pacific region. So the questions raised by you are considerable ones. They require a lot of attention in the days to come. We thank you. We can't thank you enough for having raised them and having outlined them in such an insightful presentation. Frankly, for me, the session went just by quickly and I couldn't notice the passage of time. Thank you so much, sir. I would further like to thank Professor Peter Van den Bossche for his clear analysis of the multilateral trading system in 2021 and the way it's going forward. The reforms suggested by you, sir, are in many ways inevitable, and therefore, I believe that it is most important for a lot of discourse to take place on these issues. And thank you so much for kicking off this discourse in such a magnificent way. I should also be amiss if I don't thank both of our resource persons for having participated in that lively, interactive, wonderful Q&A session, which was extremely informative to one and all. Thank you so much to both our guests of honor. I would further like to thank our beloved Dean, Dr. T.R. Subramania, without whom none of this would have been possible. He has since taking over here at the CMRU School of Legal Studies. He's been extremely busy in organizing many of these events in terms of enhancing scholarship and in terms of improving the academic credibility of our institution. Thank you so much, sir. I would further like to thank our university authorities, Dr. R. Praveen, our registrar, who's been here today throughout with us, our Dean Academics, Dr. Suja Bennett, the director of our Research and Innovation Center, Dr. Bhaskaran, and many of the other administrative authorities of our universities who have lent considerable support in having made this event a great success. Thank you all very much. I would also like to thank all the participants, the resource persons, the paper presenters, our own students of the CMRU University School of Legal Studies who've been very enthusiastic in having registered to participate in this event.
students and faculty from many other universities across India and of course across the world for having registered to participate in this event. Finally, last but not the least, I would like to thank all the service providers and support staff, including the media, for having covered this event and made it a grand success. Last but not the least, I'm sorry, I've said this twice, but definitely last this time, I would like to thank our great and wonderful team, which has been organizing this event. Of course, many of you have been talking to Shivani and Mithike. Many of the participants would have exchanged emails with Professor Mithike and Professor Shivani. Also, the other person behind the scenes who has been tirelessly working the entire day today, getting this session technically through in a wonderful way, is Professor Ardra. She's been great. Thank you all. Thank you so much. A very good evening to all of you.
Thank you so much, sir. With this, we have come to the end of the inaugural session for the event. Participants, kindly note, the same link will be used for the plenary sessions tomorrow. The first session will start at 10 a.m. sharp. We request you all to be logged in at least 10 minutes prior to the first session to avoid any delays in the furtherance of the conference. With that, thank you all and wish you all a very good evening.